will be subject to the outcome of both the sides of the councils. Because one covered by that page 7.
I think where I'll ask my law clerk to prepare to get into no, we can also do it. We'll do it and prepare a chart. I don't know whether
so in fact, that chart is present in the affidavit filed by
your rival parties may not come together. Meetings of minds may not be possible. So we'll do it. We have a law clerk. We'll ask the law clerk to prepare it.
My lord,
the state of the
as councils,
But from the record, we don't have to seek instructions from the client.
yes, my lord, as councils, there is no question of meeting of the mind. We have to go by the record before the court. So therefore, my lords, we will go only by the orders that my lords have passed and the outcome of those orders and the statements made by the state of MP in its affidavit, how many people have been appointed when. So fortunately, we have one of those affidavits where they have made categorical statements to that effect. So my lords, that will be basic.
Can you make a comment table?
It's already there.
Yes.
You all have to sit down on a common table, which may not be possible.
Would my lord consider seeing
You may have to provide something more.
No, my lord, if your lordship can make it clear, my lord, if your lordship make it clear in the order that what is actually required from both the sides of the councils. Because one thing is very much clear, my lord, that when the advertisement was issued, it was challenged. Your lordship passed an order that because the matter is pending with the Honorable Supreme Court, all entire process will be subject to the outcome of the Honorable Supreme Court's order in the Vijay Sharma's case. Subsequent year to my lord, the appointments have been released by the state.
First prepare that. Our law clerk will do it. The court will not depend upon the data supplied by the parties because they may not come to terms. And we can list on 19th.
Can I just take
19th or 19th, which one is there?
19th, my lord, 19th.
Can I just take 30 seconds if my lord will permit just 30 seconds?
19th is the polling day. Alright, then 22nd.
Can I just take 30 seconds? The chart is already ready.
Doesn't matter. Polling day will not make a difference. When we hear that
Can I just take 30 seconds, Malaj? The chart is already ready. The chart is already ready. It is before my lords in a compilation at page 34. The state of MP filed the chart before the Supreme Court. Can we just show that it will resolve the problem? The chart is filed by the state of MP in an affidavit before the Supreme Court.
That must have been filed prior to the order.
No, it is filed for the proceeding in the 8th April order. When the 8th April order was pronounced, that time the state of MP filed a chart. And that chart answers all the queries as the lords would want to know about. All those queries are answered in that chart. My lords, could please have page 34.
Just one
case. Which case?
My lord, it was filed before the Supreme Court in the present application filed by state of MP. That is where I said that fortunately there is an affidavit which has been filed by state of MP. The state of MP in that affidavit filed in the present application in which this order has been passed at least has set out the dates on which it gave the appointments. Now, my lords, those dates have to be juxtaposed only with my lord's orders. My lord's orders saying that all appointments will be subject to the outcome are prior to these dates of appointment. Now, that takes care, that is completely in accord with the Honorable Supreme Court's order at page number 7, my lord, the last few lines and over to page number 8. So that is probably the only comparison which we can't have a better thing about the dates of appointment then the statement made by State of MP before the Supreme Court, the current proceeding itself.
Where exactly is the chart
Yes,
in this compilation?
my lords. Yes, page number 31, my lords, in this compilation, and if my lords will come to page number 34.
We don't have a copy of this compilation.
No, everyone has been
Please bring that artifact was filed, you know. Please bring that chart which was filed before the Supreme Court on record.
page
It's
34.
contained.
It is not, we don't have a copy.
Sir, you were a party to the Supreme Court. Why should you delay such matters?
Supreme Court records are not part of the records here.
Your lordships would only be required to look into this fact whether the appointments have been issued after the interim orders being made subject to the outcome of the Devesh Sharma's case. If the fact remains if this is to be placed by the state of MP, the dates when the appointment orders have been issued, those were issued after the interim order was passed by this honorable court. So, perhaps all those would be now covered by the Supreme Court verdict that they cannot be retained in service. So, perhaps the state of MP can very well tell those two dates of appointments being issued.
It's fine. Please see page 34 for a minute. Please see page 34 for a minute. It is specified there.
Alright, so we'll direct all the parties to give a tabular illustration based on the order of the Supreme Court latest by 19. So that we can take up this matter on 23rd.
Can I make one request to the court, please? My lords, so far as the dates of appointments are concerned, State of MP is the best authority to give those dates. We will not be able to give you the dates, save and except for what is stated by State of MP on record before the diverse courts. So let State of MP at least put before my lords the dates on which it gave the appointment. The rest is a matter of record of proceedings of my lords court. Proceedings in the present matter.
You have to give precedence to the lady. Yes.
My lords, may I
And
just
to be
react
an
to
advocate, my lord.
Is there another way?
my lords, that's all right. I know people are anxious, but I'm still kind. They are kind enough to allow me to go on. My lords, I was saying that so far as the dates of appointments are concerned, State of MP is the best authority to give the actual date of appointments. Now, all that has to be seen is the actual date of appointments and in conjunction with my law interim orders that had been passed, that any appointment will be subject to the outcome. If those appointments have been made after my lord's orders in the present proceeding, then clearly those appointments will go. But if the appointments have been made before my lord's directions, then perhaps they may be sustainable in view of the Honorable Supreme Court's orders. So, my lords, we have a benefit of this affidavit that was filed before the Supreme Court on 6th of April 2024. But the State of MP, let the State of MP file before my lords by the 19th or so the dates of the various appointments that it has carried out in these present proceedings given to the B.Ed candidates. My lords, I think that will be important because then it's a very simple exercise. It won't take too much to be.
Exactly.
The date of the order passed by my lords is 7th July 2022. 7th July 2022 is the interim order passed by my lord. So all appointments admittedly are after that. My lord could see the 7th July 2022 order.
We made that table. It's been clear that parties are on. Council for the respective parties are on. Next. The apex court by its order dated 8/4/24 and decided to file by the state of Madhya Pradesh. State of Madhya Pradesh. Review by state of Madhya Pradesh.
My lord, it was an application for clarification. It was an application for clarification. It was an IA. It is noted in that order. My lords will find in that order of the Honorable Supreme Court. My lords will find that the court notices the nature of this application. At page number 5. Application has been filed, taken out by state of Madhya Pradesh, labeling it as an application for clarification. My lord, second paragraph, page 5. It was not a review, but the Honorable Supreme Court then proceeded to treat it as one.
They have treated it as a review.
Yes, my lord, they will go ahead and treat it as a review.
Has clarified the its earlier judgment passed on 11/8/23 in the case of what were the parties there?
Devesh Sharma versus Union of India.
Union of the aforesaid judgment in Devesh Sharma has been made prospective on certain conditions as contained in the said order. Next. Certain relevant data and documents are required to be filed by the respective parties, especially the state of MP, including the various appointment orders of the BA appointed, so that the can be resolved. Next slide. The parties are directed to file a common capital illustration containing all the necessary and relevant facts and documents in regard to all these parties in these petitions. Are there some other petitions also? No. Besides what are listed today, any other petition? These petitions, latest by 19th November, latest by 22nd November. List the case of 20th. Sorry, as agreed to by the parties.
I'm paying my lord.
You must consider
IA number 5 to 8.
IA 5 to 8 of 24 filed today by the
interveners in 13768 of MB.
shall also be considered next.
Would one not consider fixing the time on 23rd minute?
They are at liberty. If they want,
Would one not
they are at liberty.
would one not kindly consider fixing the time?
They argue on this issue. But KC Nandan does not survive. And the moment KC Nandan goes on, nothing is there. This is an argument by someone whose intervention till date has not been allowed.
Would one not consider fixing the time on 23rd minute?
Even his intervention
Council who are appearing virtually, do they want any time to be fixed?
Yes, my lord.
Yes, we want the time to be fixed, my lord, but only with the requested instead of 23rd, if we have taken up on 24th.
We are comfortable with it. We need to manage, but some time may be fixed.
24th on.
So then it will be 2:15 at on 23rd and 7th.
By 23rd, there would be some problem. 24th, if it would be made, my lords. May I request 24th, my lords? 24th.
Yes, any objection to that? 24. 15 years.
24th.
Please tell us who is appearing for whom, one by one. No, can you all who are appearing for virtually, you are appearing for whom?
I am appearing by
Miss
Miss
Arora
Arora Dwivedi.
Mr. Arora and myself are appearing for the petitioners in the three matters.
How will you inform us then in writing?
Well, our local council will give the appearance in writing.
So please put it in the chat box.
We will do so.
I'm preparing for the interveners, the B.Ed candidates, appointed B.Ed candidate, Mr. Patwalia was leading us minute. I mean the other matter, the Vipin Kumar Trivedi matter, our intervention application stands allowed, so we are respondents.
So please put that in the chat box. So that
We will provide the same in the chat box.
So it is 24th of April, 2:15 p.m.
All other high courts have decided this issue and confirmed by the Honorable Supreme Court in the past 1 month, making it all the appointments which were prior to the judgment, but post the interim order have been rejected.
That is the
All
view
high
of
courts
my
across the
friend.
country have done.
That is the view of my friend Malad, we have a lot to say.
All right. It is not listed today. Along with WP. One five. I want it.
768 will not survive. उससे कोई ठीक करने का मतलब नहीं बना. And this will be fail to understand why they are pressing 167. Judgment of the Supreme Court is
7, 6, 8.
It's not a PI.
You are being appointed. Then what is then? You are already appointed. No, we are talking about there are only 2 persons in 13768. Persons in 768. That must be some other number. Which is that number?
Issue is not the same. Issue is the time different. AC number 3.
Just नहीं आप बताइए उसका नंबर क्या है 100 87 2024 ठीक है कोई फ्रेश केस लगा है
creating because it's very difficult here. Well, it does not become infructuous. The prayers in 13768 may be seen. I don't understand that why this argument being canvassed that it becomes infructuous. We see the prayer in 13768. It is by DLN candidates. That prayer is identical to the other matters. And I understand the petitioner saying it becomes infructuous. An intervener who is still not allowed is saying this.
Yes, unnecessarily not. This is a vexatious litigation case in Andhra. So, this Vipin Kumar Trivedi, they have not been appointed. So, Vipin Kumar Trivedi, I will argue, why we should be compelled to argue within the case and the petitioner who have been appointed.
Yes, both of them have been appointed. I'm sorry,
let them say this. Just a minute, please, yes. So then, why should we continue with the commission? That has been settled by the Supreme Court now. They are not agreeing by the order of the Supreme Court. They are. How are they agreeing? By the appointments of the governor holders has not been said by anybody. They have and you will continue in service. It is only the B.Ed candidates who are apprehending a nomination or being ousted from service.
That is the exact prayer. Please see the prayer in KC Nandan Sahu for a minute. That is exactly the prayer that B.Ed should not be treated. Please see one of the prayers at page 29 of the petition. And that is
given by the Supreme Court.
So therefore, all that we want is this petition be allowed in terms of Supreme Court order. That's all. That's all. Other high courts have also done where similar prayers were made. That is what we have produced on record.
That has been satisfied by the Supreme Court.
I'm sorry, Bharat?
To the extent. What is the prayer?
Please see page 29 is the prayer of KC Nandan Sahu. 7.2 and 7.3 are very important at page 30.
It cannot be a co-one. It cannot be a PI that also we know the
But if you don't let us argue, how would we argue, please, if you don't mind?
Matters PI does not, is not maintainable. And valid.
Kindly add 7.2. If I may read 7.2 for a minute.
Because you are agreeing with your appointment Mr. Akbar. 7.1 you have sought washing of this notification which has already been washed. He did not wash. Then we come to 7.2. Is to issue appropriate writ election not to treat B.Ed candidates that have also been held.
Indeed.
Actually, certain conditions, certain clarifications there. And even if those clarifications are in favor of the B.Ed candidates, you are not prejudiced. When you hold the diploma, which has been treated as the correct qualification, then 7.3 is not liberty to the state to treat so and so. So BSTC candidates क्या है ये? हाँ? BSTC क्या है? What is BSTC? This is also satisfied now.
BSTC Malus were asking stands for basic school teaching course, teaching certificate, I'm sorry.
Also done now. 0.4 is also over there. And 7.5.
7.3 and 7.4 is not over. If I can intervene in between, if your lordship, there is some because actually we left it believing in these matters now we posted on 21st. But I've been apprised that there is some objection raised regarding the matters becoming infructuous, which is not the position.
And all that we are praying is this writ petition needs to be allowed in terms of the Honorable Supreme Court's direction.
But if two candidates in a bunch of the petition of two persons have got the appointment, will not render the entire petition infructuous because it is about the validity of the rules, the qualification to be prescribed, and thereafter the appointments to be given only those who are eligible as per the NCT initial notification once the notification of 11th August 2023 was questioned set aside.
You take it up on 24 then.
Marvelous. Obliged.
Or 24, along with WP 10087 of 24, as prayed for by Sri Chand.
Obliged.
Grateful, Madam, deeply grateful.
Interim order doesn't survive now after the Supreme Court judgment. So it does not survive. आज पता लगा है तो नहीं लगा इसमें कहाँ आ गया? नहीं उसका clarification आ चुका है. So now it doesn't survive. Yes. We come back in 10 minutes.
Grateful moments.
Grateful, Madam.
No, if any party has any hesitation to answer the queries, husband or wife, in the open court, then we can hear you both in the chamber. That will be better.